Hi, good morning, everyone. So today we will be sharing the topic on Introduction to Mergers and Acquisitions. So these slides were prepared by Daryl and Co. Because a few of us from our firm, we attended a talk organized by them in Kelba. So then now I'll be sharing what we had learned actually, or my experience really to all of you. So, about mergers or acquisitions, I believe, I think most of you have heard about it, and people always talk about mergers. I'm doing corporate M&A. So yeah, what is it exactly about? And also the aim today is to actually share with you the general idea of the practice of mergers and acquisitions. So there will be 5 aspects of our topic today. So first one will be, what are the types of mergers and acquisitions? The second one, structuring, how do we structure the acquisition? And then what's the legal framework of it? And then the documentation and due diligence for M&A exercise. And then the last point would be on the principal documentations in relation to mergers and acquisitions. So for types of mergers and acquisitions, broadly speaking, there are 3 types. The first one would be merger of a business. Generally would mean, a new company will be incorporated, and then people use the new company, the newly incorporated company, to acquire the business and assets of the other 2 target companies, and then basically combination of business and then 2 become 1. Okay, and then the second one and the third one would be acquisitions. The second one is acquisition on shares, which is a share sale transaction, and then the third one would be asset sale transaction for acquisition of business or assets of a target company. In Malaysia, the common ways would be through the second one and the third one, acquisition of shares and acquisition of business. And then today's actually the focus will be on the second one and third one also. Okay, the second one and third one, which is mainly these 2, share sale and asset sale. So what are these asset sale? What are these share sale about? Share sale would mean you actually buying shares of a company. So when you're acting for a client, so the target will be buying over companies, right? So it can be via 2 ways. It's either you buy the shares of the companies or you buy the assets of the companies. And then of course there are pros and cons for these 2 types of transactions. Share sales, mainly these things, some of the key points would be the sellers would be the shareholders of the company. For example, A. Senyan Berhad, then the sellers would be the shareholders. Shareholders can be individual or companies also. And then let's say you're acting for a buyer, you cannot choose what you want for share sale in the share sale transaction. Share sale transaction, you will need to buy everything because you're buying the shares. So you can't choose and pick the assets that you want. It's like a package. So you need to buy everything. Once you take over the company, you owning the shares in the company. So then you actually, technically, you need to accept all the assets and liabilities of the companies because you're acquiring everything with its liabilities. Of course, typically, for a share sale transaction, it will require more extensive due diligence procedure because, like I said just now, you are technically buying all the companies, everything. You can't choose. So you also, take over the liabilities. So you must be very careful with this share sale transaction. For asset sale, on the other hand, the seller will be the company. So the company would sell off, dispose their assets. Assets can be in any form. For example, you just want to buy their receivables. For example, you just want to buy their IP rights. For example, you just want to buy their contract rights, right? Because the company has entered into contract with some very important customers or suppliers and you want those things. And so you buy those assets. And buyer can also select the employees you wish to re-employ. So of course, then asset sale, you can pick and choose what you want basically. And then in terms of due diligence, it will be more limited to the target assets that you would like to acquire only. And then for structuring the acquisitions, it's very important to understand what your clients want to achieve in each transaction. You need to understand what they want. Of course, for example, certain license that is tied with the company cannot be transferred. So of course, then you need to do via a share sale transaction. You cannot just buy the license over because the license cannot be transferred. So you need to acquire the whole company through share sale transaction. And then you need to get involved from the start to understand the client's needs, involved in the meetings, understanding the clients, what they're trying to achieve for the transaction. Okay, so for these slides, right, it's also about, in every transaction, there will be two parties. So because it's a transaction, right, there must be a seller and buyer. So it depends who you're acting for. Are you acting for the seller or acting for the buyer? So then there will be different concerns in playing these roles. So when you're acting for buyer, what is important for the buyer to acquire as part of the transactions? Licenses, contracts, is it IP rights? It depends. Or then you need to check the unknown and perform your due diligence to check out the liabilities and the extent of the exposure of the risk. Then what will be the timeline? What are the legal framework? And there are also tax considerations. Tax considerations, we will talk about it further on stamp duty also. And then when you're acting for seller, you need to think about what's the nature of exit. Is it a management buyout? Management buyout, then as a seller, you wouldn't want any control, right? You will just, once you're acting for the seller, the shareholders, once they dispose the company or the assets, they don't want to control them anyway. So it depends what you want. How many shareholders, the timeline, same thing, legal framework, tax consideration. Okay, what would be the legal framework in general for this M&A exercise? Of course, then the Companies Act is the main governing law because you are talking about companies here. And directors' duties, you talk about directors in general, they will have, they will have to act in the best interest of the companies. So that's why you need to get their approval in all the transactions. When you acting for a buyer for a company, let's say, you also need to, one of the consideration would be the resolutions. The directors need to approve those transactions before entering transactions. And then for share sale, the two main provisions would be Section 105 Companies Act and 106 Companies Act. So 105 basically provides that any shareholder may transfer all or any of his shares in the company by a duly executed and stamped instrument of transfer and lodge a transfer form with the company. So 105 provides that whenever you want to transfer your shares, you need to have a duly executed and stamped share transfer form. So that's why when you're transferring shares, after we enter into a sale and purchase agreement, we also need to sign this instrument of transfer for shares. It's the same as when you're transferring for land, you need to fill up MOT form. This instrument of transfer is for share transfer. And then Section 106 and constitution of the target company, it depends. There will be some. This law says that once you lodge this instrument of transfer form with the company, Section 106 that provides that you need to register the transfer form, and there will be some restriction of transfer in the constitution. It depends. You need to check the constitution. Then you need to get a waiver for it for transfer. And then on asset sale, the important one is Section 223 for any approval of company for disposal of company property which is of substantial value. This one basically says when a company disposes of property or asset, you will need to get the approval of the board to dispose the property. And then of course the general principles under Contracts Act would apply for offer acceptance, consideration, intention to create legal relations. So the next part is on public listed companies. So for every M&A transactions, the company, the parties involved, it could be private companies or public listed companies. If a public listed company is involved, right, you would have to comply with a lot more laws. For example, CMSA, Capital Markets and Services Act 2007, Malaysia Code on Takeovers and Mergers 2016, and Bursa Malaysia listing requirements. Because these listed companies, right, they are, for example, for companies that's listed on Bursa Malaysia, these listing requirements will apply to them. So this one, right, let me just maybe draw an example. For example, when a list co want to buy over or want to take over another company or assets, which is of substantial value, they will need to make an announcement. And then they will need to issue circular to their shareholders, because you need to get your shareholders' approval to approve those transactions. And then Bursa listing rules, main market listing rules, would provide those requirements in terms of timeline, when you need to issue this circular, when you need to make announcement, and what you need to comply with. Because we for example, as a minority shareholders, right, say you holding 0 point certain percentage of shares in a listed company, you want to know, the things that you invested in this company, you want to know what they're doing, and then you want to see what they have announced. Before they entering in transaction, they will need to get your approval. Yeah. So then the next thing, for every transaction, one very important aspect would be stamp duty. So Stamp Act provides that for share sale transaction, it will be 0.3% of the price or value of the shares, whichever is higher. So this one is 0.3% of the purchase consideration or the value of the shares. So the value of the shares will be based on the net assets of the company. So whenever you apply for this stamp duty adjudication, one of the supporting documents would be the AFS of the company. That's where how they actually check the value of the shares for the shares that you are acquiring. For asset sale, generally there will be a scale here, 1 ringgit for every 100 on the first 100,000, 2 ringgit for every 100 on any amount exceeding 100,000 to 500,000, 3 ringgit for every 100 on any amount in excess of 500,000. And then, of course, you need to consider the exemptions that may be applicable to each transaction. In this slide, there's this thing on exemption for SMEs on paying stamp duty for any instrument executed for M&A between 1st of July 2020 and between 1st of July 2020 and 30th June 2021. Actually, in addition to this, there's also some exemptions under the Stamp Act. For example, what I can think of now would be Section 15A of Stamp Act, which provides for, when there's a transfer of properties between associated companies, then it can be exempted. And also, I think 15 is on reconstruction of companies. So when you do restructuring, there could be some exemption. You need to check because there are a few requirements to fulfill. And sometimes, when you're transferring assets or transferring subsidiaries within the group of companies, you need to go and check whether this exemption will be applicable, because these exemptions, sometimes this stamp duty can be quite a huge amount. Okay, next one would be RPGT Act. So some people would think that when you buy an asset, you attract the normal RPGT Act, right? And then what people do is that they will buy the shares of the company instead of the assets, because a company, A Sdn Bhd, can just own that land, and you just want that piece of land. People would do through share sale instead of the normal land sale and purchase transaction. But then need to be very careful also, because real property gains tax may apply for a real property company. So if you fall under a real property company, you also need to pay your RPGT. And real property company is defined as when your total tangible assets consists of 75% or more in real property and or shares in another PRC. So this thing, if you fall under this category, you will also need to pay RPGT and need to file the forms also, the relevant forms. And then in terms of employment regulations, whenever you do M&A, some people may want to terminate some contracts of employments with the existing ones, because when you take over company, you want your people to be in your management. So these are things that you need to consider. Competition Act 2010. So far, there's no merger control in Malaysia, but I think this is here for you to consider because, for example, because for very big transactions, right, when two companies merge, it can be very, very big, which has a very controlling market share in the markets, in the specific industry. So once you become very dominant in the market, you need to be very careful with your every commercial decision, because it may fall under this anti-competition law. And it can be the penalty also is quite huge. And I think recently there are many cases on Competition Act enforcements also, but this is more of a post-completion consideration. And then there's specific laws and rules for specific sectors. For this, for every M&A, you also need to think about, for example, when you're acting for foreigners, right, Chinese company or any EU company, or these from people from the States, people from even Singapore, Singaporean, whoever, these foreigners, you need to check whether there's any foreign restrictions for them to actually be involved in certain industry and certain business. For example, if you want to open a hypermarket in Malaysia, you will need to apply WRT license, which is called the Wholesale and Retail Distribution Trade license. If you want to set up a hypermarket chain in Malaysia, for example. And you also need to consider whether, even though there's a foreignership and you have Malaysians there, whether these Malaysians are Bumiputra, because they are two different things. There can have Bumiputra restriction also. And then for specific sectors, actually certain sectors in Malaysia and industries in Malaysia are very restricted. There's foreign restriction. This would include some banking and financial services sector, for example, insurance business, or energy supply business. Yeah, these are some of the examples. Okay, for stages of the transactions. The first one would be on preliminary agreements. So before we entering into M&A transactions, say we are targeting to buy this company, which is a manufacturing company. Then what would be the preliminary agreements? Before you even, when you buy a company, you don't know what the company has. So usually the parties would enter into a non-disclosure agreement, because the vendors is actually the seller, right? It's actually open up their book to show you whatever they have in the company. So they also want to make sure that you don't disclose to other people. So that usually people would sign an NDA and then a term sheet, or you call it letter of intent or MOU, which is sets out the principal terms. Who are the parties who will be the parties to the transactions? What's the timeline for due diligence? How long you can do due D? What's the consideration be like? The range of consideration? Is it exclusive or not? Because it could be some bidding deals, right? Say it's a very important assets, a lot of people want to buy, then it could be through bidding, and then this whole target, the seller is only open up to certain people, like for example 5 bidders. There's only 5 bidders to go and check their company, and then of course in the end there will be only have one buyer. Then this thing, exclusivity is about whether it is exclusive to one party or not, or many people. Or then binding and or non-binding for the terms in the term sheet. So then after the parties sign all these agreements, then they will commence their due diligence. Due diligence. What is due diligence? Due diligence is basically checking and evaluating the risks or any liabilities for you to know before you actually buy this company. There's this thing, let the buyer be aware, caveat emptor. You need to know what you are getting into. And we as lawyers, that's our role to actually help our clients to perform, to check the company, because we know what will be the legal risks that we'll be facing. What's the limit, the extent of liabilities that they will have if they take over this company. That's where we can add our value to it. So it's all about fact finding, evaluation of risk, making informed decisions, and then red flags. Red flags here means if there's any important significant issues that will affect the transaction. For example, when you perform duty, then you check on this company, then you notice, there's this non-compliance issue of their, say for example, their labor issues. Then you need to highlight to your clients, because this thing can affect their decision whether to actually eventually enter into the transaction and take over the company. And then this due diligence is important for you to actually draft your definitive documentation also, because there will be other professionals involved in the due diligence process, not just legal side. There will be financial DD, tax, and business people. So these people would check other aspects of the company, because we as a lawyer, we check the legal stuff, but then for other professionals, right, financial DD, for example, some all these big four auditors, they will need to check their accounts, whether they have been paying tax properly, whether there's any mismatch or not of their accounts. Okay, so what do we rely on when we perform due diligence? Of course, the fundamental thing would be the public searches. These public searches, the common one would be CCM search, winding up search. We want to see whether the target company is actually wound up. We want to see whether these directors or individual shareholders are bankrupt or not. Also for CCM search, we cannot just purely rely on CCM search, because CCM search is a registrar of companies in Malaysia, and they actually update this information in their search result based on what has been filed by the company. So we lawyers, we need to check further. CCM search can only provide you some brief information about the company, and we need to go and see the statutory documents and what are documents required under the Companies Act to show that you are the real, your ownership and you have the good title to your shares. Then we need to also understand the business and regulatory landscape surrounding the target. For example, if you are buying a manufacturing company, of course the fundamental license will be manufacturing license. You need to see whether you're operating a factory and they have this valid manufacturing license that's still subsisting. You need to see whether they have a proper fire, for example, fire certs in respect of the factories. You need to see whether this whole piece of land, where the factory is built on, has CCC or not. So the usual scope of legal due diligence, usually for M&A transaction, we will look at three years of the records of the company. So it depends what the parties have been agreed upon, because some buyer actually their risk appetite is bigger, so they only want us to do limited due diligence. But usually people will do 3 years and then one will be the materiality threshold. This one, parties will have to agree also. It usually depends. Let's say it's a profit-making company. People would base on their profits, 5% of their profits. Let's say the company is making 100 million, then the threshold will be 5 million. And let's say it's a loss-making company, then people will look at their net asset of the company. It is also maybe 1%, 5% of the net assets. And then due diligence checklist. Okay, for due diligence, of course, when you check a company, there are many aspects to it. And then the slides here set out the main aspects that we will look at. And this would be the common scope of due diligence for every M&A transactions. Of course, general corporate, we need to, the sub-points would be incorporated in this thing. We need to make sure the company has secretarial records. If there's interest in any other undertakings, the capital structure, what is the constitution, is there any restriction for them to sell the shares, what will be the restrictions, then we need to get the approval. And then if there's any shareholders agreements among the shareholders of the company, of the target. This aspect is important because we don't want a situation where, you know, our buyer take over the company and then some people step in to say that they have also interest in those shares. So that's why we need to check all these things properly. Our job is to get, you know, our client to have a very good title to shares. And then this one will be checking their secretarial records. That's why in every due diligence exercise, we always trace the shares. And then second one, the important aspect would be these assets and real property and any other assets. You know, say example, manufacturing company, you will need to see the land title of the factory they are operating their business, what's their assets they have, the machines, you know, if there's machines, do they have a DOSH license, the title of the land, let's say if they lease a factory warehouse, then we will need to see their lease agreement, tenancy agreement. For IP, I think increasingly it has been very important recently, because if you are acting for, if the target company is a software company or, you know, a very high-tech semiconductor industry company, then you need to check whether they have good license to actually for their operation, for them to actually run the business. We need to see if they license if they are using other people's patents, then whether this license agreement is going to expire soon. These are the things that we need to think about. For licenses, permits, regulatory approvals, we need to check whether if there's any non-compliance, because certain licenses or approvals would come with certain conditions. We need to check those conditions, whether they have been, you know, satisfying these conditions given by the authority. And then change of control. Say for example, this company has a approval from Bank Negara, and then they have this change of control provision, then to say that if there's any change of shareholdings in the company, then you need to get their approval. And if you don't get their approval, the BNM has the right to revoke the license, for example. This then would be a very important point for you to take note. You need to highlight to client, and then we will need to get approval from BNM before we proceed with the deal. Okay, then banking and finance. This would be the financial arrangements involving the company. You will want to know, you know, how much loan the company has taken out, then if there's any encumbrance or not. So, because when you take out loan from the banks, right, sometimes they will create charge over your shares or over the assets of the companies. So we will need to see whether there's any encumbrance, and then whether, you know, clients would want to continue with this financial arrangement with the banks or not. Because some people would actually pay off first before they proceed with the deals. And then of course, whether there's any change of control, because the bank will also want to know, oh, there's a change of shareholders, they want to know who will be the new shareholders, who will be the incoming ones. So sometimes we need to get their approval also from the banks. Then the next one will be contracts. This is also equally important. Contracts, some people, when you buy the companies, right, it's because they have certain relationships or ties with the suppliers or customers. So some people only care about this. It depends on what your client wants. That's why it's very important to understand what your client wants. If they really want those customers and suppliers, right, and they value the relationship so much, then this can be a very important aspect to it for contracts. You want to see whether not just the change of control part, you want to see whether there's any termination, how can they terminate, and what will be the period of relationship, can they renew or not, can they actually terminate it without any reasons. If they can terminate no reasons, then you need to highlight also, it's a very important point for clients to actually take note. What's the point if they buy over the company and these people can just terminate without any reasons? Okay, then employment part. What we look out for could be some non-compliance issues. For example, as you can see in the news also recently, for the top glove, there are so many employment issues or labor issues, and if it's a manufacturing company, usually they will have employed a lot of foreign workers. Then they need to provide accommodation which is in compliance with the minimum standards also. So, and then these are things that we need to check. For key personnel management contract, you also need to look at the employment contracts, whether these people can just leave the company anytime. If you want this management to be continue in the company, then after the acquisition, you want to see how can we actually keep them, right? So you'll see also. And then for EPF, SOXO, and AIS, this one, the liability can be quite huge because based on my experience, I did one before, and the exposure of liability is like few millions because the target company didn't actually contribute to EPF and SOXO properly. There's a shortfall of few percent. So this one we need to be very careful also. The next one will be environmental issues. It depends on the scope of due diligence. Some people, depends on the target company. Certain industry has very high standards, and environmental issues can be an important factor for your buyer, for the client to actually consider whether to get into this business. There are actually a lot of regulations under Malaysia that they control you how you can dispose the waste, how can you dispose your air from the factory side. Okay, and then the next one will be litigation and other regulatory action investigation. This would be not just the litigation, it is also can be, some action taken by some regulatory agencies or government authorities. This one, of course, you don't want to buy over a company which is under investigation or subject to certain disputes. Okay, due diligence report. When you're acting for a buyer, your buyer want to see what the company has and the exposure of liability they have if they buy over this company. So then our job also then was to draft the diligence report. It's something to, it's not easy to actually draft report also. It must be very precise, and because there's reliance basis, as in your client can actually rely on your report to a certain extent, depends on the scope and the assumptions. Usually in the due diligence report, there will be a summary, there will be material issues list, and we lawyer, our job is to make sure it's easy to read and navigate. And then the report and findings of other professionals would be financial DD report. Okay, due diligence for seller side, right? So far, I have not done before, but I have seen before a vendor's due diligence because the target was quite a big group, and then when the seller want to sell their assets, they ask lawyers to check their companies also because they want to know exactly what they have and what they don't have. So then what people do with VDD, vendor's due diligence report, they will share it with the potential buyers for them to have a look first on a non-reliance basis usually. So for example, if I have a seller, I want to sell a lot of subsidiaries. Say I have 5 companies, this whole group. Then I will ask lawyer to perform due diligence on my companies. And then I will share this report to all the potential buyers. Say they are like 5 or 7. Then I will show them what I have. So then they will consider what they're getting into. This part about controlling flow of information and documents. Okay, for certain transactions, lawyers, the counsels are involved in uploading the data to data room or the virtual VDR online. And then they will set the rules of data room. Okay, principal documentation. After we sign the term sheet, right, or MOU, then we will proceed to drafting. After we perform due diligence, everything is clear. We know the issues already, and we know the limit of liabilities already. Then we will, and clients agree to go ahead with the transactions, and then we will start with the drafting these principal documents, which is the transactional documents, which is the transaction stage already. So this thing for share sale transaction, it will be share sale agreement. Share sale agreement is quite a comprehensive agreement because it just covers a lot of things. Later, I think the later slide will have some more details to it, and then there will be disclosure letter given by the seller. This disclosure letter is more of the specific issues that we have cited or we have highlighted to clients, and now the seller are telling us, oh yeah, this factory, the manufacturing license is expiring, for example, and it already has expired. They are telling us now, once it's included in the disclosure letter, as a buyer, you cannot rely on it. As in, this is the fact that's given by the seller. So later on, after the transaction, you cannot say that, you cannot go back to tell the seller, oh, you didn't tell me, because they already disclosed to us. So for asset sale, there will be asset sale agreement, disclosure letter, same thing. And then usually there will be a deed of assignment or novation of contracts. Because, for example, like you want to buy this company because you want to buy their assets because they have certain rights of contracts with very important customers and suppliers. So then they will assign these contracts with you to the new buyer. Notices and letters to employee. This one, when there's a change of the ownership of the assets, then they will need to inform the existing employees also. Okay, the important clauses in a share sale agreement. The first thing, of course, will be purchase consideration. What would be the formula? Because sometimes when you buy over a company, the transaction can be quite long. So people don't have a fixed consideration yet. It will depend on 6 months down the road, what will be the accounts like. So people will have to agree to a certain mechanism to determine the final purchase consideration. Because then there's also CP period for you to fulfill. CP, conditions precedent, generally means something that conditions imposed on buyer or seller to satisfy before they can proceed with the deals. This would be approvals required, for example, from the regulators, or you need to inform, for example, like I said just now, the example I given, bank negara approvals, you need bank negara approval, then of course you need to put down as a conditions precedent, because you can't just go ahead with the deal without getting their approval. This would be in breach or non-compliance. Yeah, then there's condition subsequent also. This is less common. It's more of obligations or conditions imposed after the transaction, post-completion. Convenience pending completion. So for a transaction, right, once you enter into a transaction, you sign an agreement, a share sale agreement or asset sale agreement. The first thing, of course, then you need to have time to satisfy the conditions precedent. Once all these things has been satisfied or fulfilled by the parties, or it could be waived by the parties, then the agreement will become unconditional. Once it's become unconditional, then we will proceed with completion. Completions, of course, then there will be a period between signing and completion. But then, of course, many things can happen in between. It can be 3 months, 6 months, or even some very big transaction can be a year. So a lot of things can happen. That's why then we will also have this convenience pending completion. We want to make sure that before completion, the companies wouldn't do anything, out of our, things that we don't want. Like, for example, they go and bury their contracts, they go and use the company to borrow more money, or they incur more liabilities. They go and charge their assets, all these things. So this convenience would be the convenience given by the sellers to actually not to do anything, maybe without the buyer's approval or consent. So they need to let us know before they do all these things. Okay, then another very important aspect in the transaction, in the share transaction, share sale or asset sale, will be the warranties. So we perform DD, we check their companies. We know, the companies, okay, the shareholders have very good titles to their shares. The accounts are okay. They have the valid license. Their customers and suppliers are legit. They have proper insurance in place. And other aspects like IP rights, they really own all these things. Of course, then warranties, once these things supposed to be given by the sellers. So it's like you buying some, say you go and buy gadgets or a new computer. Of course, then the seller will also give you warranty, like, this thing, if anything happen, then you can come back to me and I will replace with a new one. It's the same, somewhat the same concept. It's a warranty given by the seller also in a share sale transaction or asset sale. So they give you some warranties, like to say that ownership, okay, I have good title to this ownership. I'm the legal owner, I'm the beneficial owner to it. And my accounts I disclose to you are all accurate, up to date. And I have valid license. These licenses are subsisting and they are not expiring soon. I have these customers and suppliers. I have the contracts in place. All these tax issues, there's no issues, and there's no pending litigation or subsisting litigation or disputes involving my company. I have this number of employees. My employees cannot terminate their contract within how long. I really own these IP rights, and all the information that I've disclosed to you are accurate. So warranties, what will happen if once they've given you this warranty, it can be relied upon by the buyer. If they breach any of these things, right, then you can go after them. You can tell them, you tell me this, but the thing, once I take over, after I take over, I realize this happened. So when it comes to warranties, of course, when you're acting for buyer, you need to make sure that everything is covered, because this is our reliance. More like, if anything happen really, then we will go after them and we will tell them, but you give me this warranty. Okay, then What is disclosure letter? Disclosure letter is more like an exception to the warranties. For example, what I can think of now, disclosure letter. Okay, maybe this, say for example, for licenses, this business will require 2 manufacturing license, for example, but one has expired. One of the 2 has expired. Then in the disclosure letter, the seller will tell you, yeah, this I have told you, this one of the 2 licenses has expired on this date, and we are actually following up with the authorities and we are renewing it. So once they have disclosed to you, you cannot say after we take over, right? For example, buyer, you buy over already, you cannot say that, oh, you didn't tell me. You cannot go back already because they already disclosed to you. Yeah. So on limiting claims, the minimum claim amount procedure, this will be all the things that agree by the parties, how you go about it if anything happened. Then there are also dispute resolution clause. If anything happened, what will be the jurisdiction that you want to submit to in Malaysia, Singapore, or Hong Kong? You know. Okay, restricting covenants. The sellers, once they solve their property, you don't want them to also be involved in the same business or same kind of industry. It depends how the parties have agreed upon. Indemnity is your promise to is a promise given by the seller to actually compensate or to pay the buyer in respect of a very specific liabilities. If anything happen, then they will pay you. Cost remedies, termination, force majeure, and then completion. Okay. For share sale transaction and asset sale transactions, of course, then there are some documents that we will require to prove our ownership, and to prove our buyers has, in order to actually to have a good titles to share, for example, share sale, or to make sure that the shares are properly transferred into our client's name, right? We will need to cite all these documents. Resolutions, it is resolutions by the buyer to approve the transactions, or the company to approve the transactions. You need to get their share sets also to be cancelled off, and then of course then the new share set will be issued in the name of your clients or of the buyer. Share transfer form, duly signed resignation letters, because when you buy over a company, in the case that you take over 100% of the company, your people, the buyer, would have their own new directors to be appointed. Then of course you need to make sure the old directors would also be resigning. So you need to get these resignation letters, their corporate records, their common seal and stamps. This would usually be completion deliverables. So on the completion, on an agreed date, right, then they will, once the CPs, the condition precedent, have been fulfilled, then the parties proceed with completions. Then on the completion date, they will exchange these documents. Asset sale will be the same also. The resolutions approved, passed by the company approving the transactions. Title documents to asset. It depends what kind of assets here. Let's say you're buying over, the lands, then of course you need to have land titles. You're buying over some, vehicles, like it's a transportation company, logistic company, for example. You need to have the titles to the lorries. The identified contracts that have been assigned to you, to the new buyer, the deed of novation, the assignment, employment records, and then this notice to customer supply. It depends on what kind of assets are. So the documents required would vary then. Yeah, I think that's the end of the today's sharing session. Guys, have any questions? Anyone?
Thank you, Kasun. So is there any questions we want to ask to Kasun? Okay, if there's no questions, so we will end the sharing session here. So thanks a lot,
Okay.
Kasun.
Thank you.